Eminent domain. Eminent domain is the government's Fifth Amendment power made binding on the states by the 14th Amendment of the United States Constitution to take private property for public use in exchange for just compensation. Not only does eminent domain apply to the federal government and its agency, but it relegates power to state and local governments as well. Private land can only be taken if it is going to be used for public use, and the property owner must receive compensation at fair market value. Every effort should be made to negotiate with the property owner, and eminent domain should only be used as a last resort. There are three known cases of eminent domain mentioned in the Bible. The first one is at 1 King 31. This is where King Ahab sought to acquire Naboth's vineyard. When Naboth refused to sell the property, he was stoned to death. The federal government use of eminent domain in the United States began in the late 1800s. It involved a case in 1876, Cole versus the United States, when an owner of a piece of land in Cincinnati, Ohio, tried to fight the government over the taking of his land. The government wanted the land in order to open up both a post office building and a custom house. The United States Supreme Court ruled that the government and states could take land to build things for public use. Eminent domain powers are given to the government by the Fifth Amendment of the United States Constitution. The Fifth Amendment, which states, nor shall private property be taken for public use without just compensation, were placed in the Constitution to keep the government from abusing its eminent domain power. This clause protects property owners in two ways. First, the government is limited to taking property only for public use. Second, the government must pay the property owner for the property it takes. While the federal Constitution only applies to the taking of property, many states' constitutions expanded owner rights by requiring the payment of just compensation for damage to property as well. The Fifth Amendment, as originally written, was only a restriction against the federal government. It did not apply to the states. Just like the taking clause of the Fifth Amendment, the due process clause of the 14th Amendment has been used to require that when a state or local government body or a private body exercising delegated powers take private property, it must provide just compensation and take only for a public purpose. The 14th Amendment to the Constitution limits the power of states, declaring that no state shall deprive any person of life, liberty, or property without due process of law. Due process expresses a requirement of fundamental fairness. Public use. Public use is the ability of members of the public to access and use land. It is used in the context of a constitutional ban on government seizures of private land unless the land is being taken for public use. Some people argue that public use involves actual physical use of the property, as in the case of roads, schools, and hospitals. In these cases, the seizures of the land results in developments accessible to all members of the public and provides a clear, tangible benefits. Other people believe that public use also includes development of the land for public benefit, even if it's not necessarily dedicated for public use. Even though members of the public may not be using the land, it provides benefits to the community as a whole. For most of the 19th and early 20th centuries, government permitted eminent domain to be used only for true public use, such as building roads, bridges, parks, and public buildings and facilities. The court began authorizing a slight expansion of the power when they allowed allow private companies like railroads and public utilities to take property for the land of railroad tracks and transmission lines. But these companies were tightly regulated and had to provide the public equal access to the rail lines or utilities. This changed, however, with the 1954 Berman versus Parker decisions, which expanded the definition of what constitutes a public use. Just compensation is written in the Fifth Amendment of the United States Constitution. The Fifth Amendment states that nor shall private property be taken for a public use without just compensation. So, what is just compensation? Since it was written into the Constitution over 230 years ago, courts across the United States have interpreted and narrowed down the meaning of eminent domain's just compensation. Just compensation is the amount of money that a government entity or other condemning entity is required to pay a landowner when it takes a portion or the entire property. The amount of just compensation paid is typically the fair market value of the property as calculated by a real estate appraiser or other real estate professional. Fair market value does not take account of the value that owners assign to their own properties. As a general matter, the property is worth what the owner could get for it on the open market or the value that it appraises for, which is usually the fair market value. The power of eminent domain has been given to certain non-government entities, such as utilities. Examples of projects that requires takings are power lines, pipelines, and railroads right-of-ways. This power is typically granted by the state through a statute. It may require a specific application by the utility for each project. Not every such project, though, receive eminent domain power. This will occasionally occur for pipelines and power lines. In those cases, if the utility cannot negotiate an acquisition from the owner, the utility is forced to alter its route and negotiate with different owners. A taking occurs when the government encroaches upon or occupies private land for its own proposed use. Even a minimal, permanent physical occupation of real property requires compensation under the taking clause. Explicit takings are overt acts of government condemnations. Implicit or regulatory takings occurs when a government regulation has the same effect as a taking. Now we're going to talk about physical takings and regulatory takings. A physical taking occurs when the government encroaches upon private land for its own proposed use. A regulatory takings can arise although the government action do not encroach upon or occupy the property, but still affect and limit its use to such an extent that a taking occurs. Regulatory takings are based on the principle that while property may be regulated to a certain extent, if a regulation goes too far, it will be recognized as a taking. Regulatory takings can occur when the government regulation limits the use of private property to such a degree that the regulation effectively deprives the property owner of all economically reasonable use or value of property. Even though the regulation does not formally divest the owner of title or possessions. Like physical takings, regulatory takings require payment of just compensation. Inverse condemnation. Inverse condemnation occurs when government regulation condemns some or all of the use of the property, diminishing the value of the owners to such an extent that it is as if the government had condemned the property. Standard tests for regulatory takings. There are two standard tests that have been established by the United States Supreme Court with regards to regulatory takings. The first test is the Lucas test. if the regulation takes away all the use for that property, which is a total taking or a lucrative taking, has occurred. If a property owner has a lucrative taking, they are entitled to the entire value that property had before the regulation was imposed. Penn Central test. This is the second test. Under this test, a partial taking has taken place. With the Penn Central taking, the owner still has some use to the property after the regulation is imposed, but the use has been so severely restricted that it causes the value of property to decrease significantly. If this occurs, a property owner has a valid regulatory taking claim. An exaction. An exaction is something the local zoning authorities requires a property owner to give to the community in order to obtain approval to develop land. The something can be almost anything: land, a portion of the value of the land, money, or other property. To protect against government abuse of power, exaction must pass constitutional scrutiny. Government demands must be reasonably related, both in nature and scope, to the impact of the proposed development. If they are not, the exaction are unconstitutional. Now we're going to talk about 7 court cases that happened in the 19th and 20th centuries that allowed the judiciaries to define what eminent domain is. Most of these cases centered around whether the land was taken for a purpose that qualifies as public use or whether the compensation provided to the property owners was just. The first of these cases is Cole versus the United States. This case was decided in 1875. It was the first United States Supreme Court case to assess the federal government eminent domain's powers. The government seized a portion of a partitional land without compensation for the purpose of building a post office, custom office, and other government facilities in Cincinnati, Ohio. The court ruled in favor of the government. The second of these notable cases is the United States versus Gettysburg Electric Railroad Company. It was decided in 1896. Congress used eminent domain to condemn the Gettysburg battlefield in Pennsylvania. The Gettysburg Railroad Company, who owned land in the condemned area, sued the government, alleging that the condemnation violated their Fifth Amendment right. The majority ruled that as long as the railroad company was paid fair market value for the land, the condemnation was lawful. The third of these cases was Chicago, Burlington, and Quincy Railroad Company versus the City of Chicago 2 years later in 1897. This case incorporated the Fifth Amendment taking clause used in the 14th Amendment. Prior to this case, states has used eminent domain power unregulated by the Fifth Amendment. This means that states may have seized property for public use without just compensation. In the 1890s, the City of Chicago aimed to connect a stretch of road, even though it meant cutting through private property. The city condemned the land through a court petition and paid just compensation to the property owners. Quincy Railroad Corporation owned part of the condemned land and was awarded $1 for the taking, prompting the railroad to appeal the judgment. In a 7-1 decision delivered by Justice Harlan, the court ruled that the state could take land under eminent domain if the original owners were awarded just compensation. The taking of the railroad company land had not deprived the company of its use. The street only bisected the railroad tracks and did not cause the tracks to be removed. Therefore, $1 was just compensation. Chicago, Burlington, and Quincy Railroad Company versus the City of Chicago in 1897 incorporated the Fifth Amendment taking clause used in the 14th Amendment. The fourth of these cases is Berman versus Parker. In 1945, Congress established the District of Columbia Redevelopment Land Agency to authorize the seizure of blighted housing district for rebuilding. Berman owned a department store in the area slated for redevelopment and did not want his property to be seized along with the blighted area. In Berman versus Palmer, 1944, Berman sued on the basis that the District of Columbia Redevelopment Act and its seizure of his land violated his right to due process. In a unanimous decision delivered by Justice Douglas, the court found that the seizure of Berman property was not a violation of his Fifth Amendment right. The Fifth Amendment does not specify what the land must be used for outside of public use. Congress has the power to decide what this use might be, and the goal of turning the land into housing, specifically low-income housing, fit the general definition of the taking clause. The fifth case is Penn Central Transportation versus New York City. This case was decided in 1978. It asked the court to decide whether a landmark preservation law, which restricted Penn Station from building a 50-story building above it, was constitutional. Penn Station argued that preventing the construction of the building amounted to an illegal taking of the airspace by the city of New York, violating the Fifth Amendment. The court ruled in a 6-3 decision that the landmark law was not a violation of the Fifth Amendment because restricting the construction of a 50-story building did not constitute a taking of the airspace. The sixth case is Hawaii's Land Reform Act of 1967. It sought to tackle the issue of unequal land ownership on the island. 72 private landowners possess 47% of the land. Hawaii Housing Authority versus Metcalf, 1984, asked the court to determine whether the state of Hawaii could enact a law that would use eminent domain to take lands from lessors, who were the property owners, and redistributed them to lessee property renters. In a 7-1 decision, the court ruled that the Land Reform Act was constitutional. And the last of our case is Kelo versus the City of New London in 2005. The plaintiff, Kelo, sued the City of New London, Connecticut for seizing her property under eminent domain and transferring it to New London Development Corporation. Suzette Kelo and others in the area had refused to sell the private property, so the city condemned it to force them to accept compensation. Kelo argued that the seizure of her property was a violation of the public use element of the Fifth Amendment taking clause because the land would be used for economic development, which is not solely public. Kelo's property was not blighted, and it would be transferred to a private firm for economic development. In a 5-4 decision delivered by Justice Stevens, the court upheld aspects of his ruling in Berman versus Parker and Hawaii Housing Authority versus Metcalf. The court ruled that redistributing the land was part of a detailed economic plan that included public use. Even though the transfer of land was from one private party to another, the goal of that transfer, economic development, served a definitive public purpose. In this case, the court further defined public use. All right, so most of these major cases is what define what eminent domain is and how it can be used by both the federal government and state and local agencies, as well as individuals, entities that are given eminent domain power. These are the references for the court cases that are mentioned in my presentation.